Welcome to the deep dive. Today, we're moving well beyond the usual advice of just ask for a raise. We are taking a really deep, comprehensive look at the world of wages, compensation, and of course, labor rights. We're going from the personal, the tactics for advocating for yourself, all the way to the big picture stuff. We're talking about the legal tools for fighting systemic discrimination and some pretty chilling data on modern wage theft.
It's a crucial mission, really, because the information we've pulled together is meant to be a kind of shield for the modern worker. We have sources covering, well, everything. Proactive strategies for getting higher pay, those landmark laws like the Equal Pay Act, the disparate impact doctrine. And then we'll get into some nuanced critiques of minimum wage floors, and I think most importantly, some startling real-world data on just how common wage theft actually is.
And the stakes for you are just incredibly high right now. I mean, we all see it. The relentless increases in the cost of living, rent, childcare, just, groceries. So for a lot of workers, understanding your compensation rights, it isn't just about getting comfortable. It's really the difference between staying afloat and, well, drowning in debt. We need to jump in and get equipped. Okay, so let's unpack this, starting with that foundational step, proactive advocacy. Our first source has these strategies for approaching your employer, and it really emphasizes that this should be about mutual understanding, not a confrontation. You can't be passive.
No, you can't. If you want this to be successful, the research part is, it's just non-negotiable. You have to do your homework. And that means compiling real comprehensive data on market rates for your specific role in your industry and for your geographic location. We're talking about going beyond just what you've heard and using official resources. Things like the U.S. Bureau of Labor Statistics, Glassdoor, Salary.com. You have to establish the true market value of your job.
And why is that homework so powerful? It's not just about proving you deserve more money, is it? It changes the whole conversation.
It fundamentally reframes it, yes. When you present that research, you're showing your employer how fair compensation aligns with the wider labor market. For them, it stops being about what you personally want, and it starts being about how they stay competitive. It's about recruitment. It's about retention.
Right. I thought that example from the food manufacturing sector was so compelling because employers often just don't see how these small wage gaps can create huge problems for them.
It's the perfect illustration. Our source pointed out that skilled manufacturing workers were leaving for jobs in retail or warehousing. Jobs that were less specialized, but they offered maybe just $2 an hour more.
Just $2.
Exactly. So the negotiation point wasn't emotional. It was a business case. It was, this small $2 gap is causing us to lose skilled people. If we adjust wages, we stop the turnover, we cut down on training new staff, we keep morale high.
You're framing the raise as a mutual goal, showing them the return on investment. But let's be realistic here. A lot of smaller businesses, they just can't afford to match whatever Glassdoor says the median salary is in a major tech hub. Does this only work for big companies?
That's a real challenge, for sure, for smaller places. And if there are genuine budget constraints, that's when the talk has to pivot. You move away from just cash compensation and you start negotiating alternative benefits, things the company can afford.
Like what?
A flexible schedule, maybe a remote work stipend, more paid time off, funding for professional development. These are still real quantifiable benefits that improve your life and your career, even if the hourly wage itself can't move.
And for the individual worker who's getting ready for this talk, how do they gather their personal receipts, so to speak?
Documentation, documentation, documentation. You need a list of concrete wins. Taking on a leadership role, successfully training a new hire, exceeding client retention goals, finishing a big project ahead of schedule. We saw that great example of the nursing assistant. She didn't just say, I need more money, rent is high. No, she requested a specific raise from $15 to $18 an hour, and she cited her increased workload managing schedules, training new staff, and she framed it against the rising cost of leaving. She connected her contribution directly to the compensation she was asking for.
And what about timing?
Timing is everything. It has to be strategic. You approach these conversations during a formal performance review or right after you've successfully completed a big, visible project. You need leverage. And just remember, while there are laws like the FLSA that set a baseline minimum wage, over time, there's no federal law that says you have to get an annual raise just for inflation. You have to advocate for that yourself.
Okay, that brings us to the next level of this, a much sharper level. We're moving from advocating for more to legally enforcing your right to equal pay. Let's start with the big one, the cornerstone. The Equal Pay Act of 1963, which is, and a lot of people don't know this, part of the Fair Labor Standards Act.
Yes, and the EPA is very, very specific. It targets sex-based wage discrimination, period. It mandates that men and women in the same workplace, performing jobs that require, and this is the key phrase, substantially equal skill, effort, and responsibility under similar conditions have to get equal pay. And compensation means everything. Salary, bonuses, stock options, benefits, the whole package.
What's so crucial about this law compared to some of the others?
Two things, really. First, if an employer is found in violation, they cannot, I repeat, cannot reduce the wages of the higher paid person to create equality. They have to raise the lower wage up. Second, and this is a big deal for workers, the EPA is faster.
Yeah.
You can bypass the EEOC's administrative process, which can take a long time, and you can file a lawsuit directly in federal court. You have 2 years or 3 if the violation was willful.
That speed is a huge advantage. Now, the EPA is focused just on sex and equal work.
Yeah.
But what happens when the jobs aren't identical? Or the discrimination isn't about sex, but about race or age or disability? That's when we have to look at Title VII of the Civil Rights Act, and specifically this idea of disparate impact.
Exactly. Title VII is like the legal bulldozer for systemic barriers. Disparate impact deals with these seemingly neutral employment practices that have an unjustified adverse effect on a protected class: race, color, sex, national origin, and so on. The employer might not intend to discriminate, but if their policy results in a statistically significant exclusion of a protected group, and they can't prove that policy is absolutely necessary for the job, it's illegal.
So it's the effect, not the intent. That's the bottom line. This doctrine has been just essential in tearing down these structural roadblocks, often in high-paying jobs where women or minorities were kept out by just arbitrary rules.
Absolutely. Think about physical requirements for jobs like policing or firefighting. Title VII challenges have basically eliminated arbitrary height and weight requirements. For example, the Supreme Court case Dothard v. Rawlinson, it struck down height and weight rules for Alabama correctional counselors because there was no data, no proof that a certain height actually correlated with the strength you needed for the job. And we saw the same thing with the LAPD's height requirements. The Ninth Circuit struck them down because they disproportionately screened out women.
These rules look fair on the surface. They applied to everyone. But they had this clearly discriminatory effect on who could even get access to those jobs.
That is disparate impact in a nutshell. And we see it with physical agility tests, too. Courts have stepped in when tests were clearly designed to favor physical traits more common in men, even when those traits weren't really essential to performing the job. There was a case with a Rhode Island Fire Department test that overemphasized upper body strength, way beyond what was needed. The person who designed the test even admitted it was meant to favor men.
And then there's that almost unbelievable anecdote from our sources about operational policy. The construction site bathroom break rule.
I don't know. It's a perfect, if shocking, illustration of how a neutral-sounding policy can be discriminatory. So this construction site had a policy that effectively banned bathroom breaks for their crane operators. When the female operators complained, the employer's brilliant suggestion was that they should just do what their male colleagues did, which was urinate off the side of the crane.
You're kidding.
Not kidding. So that policy, while neutral on its face, created a situation where female workers faced this impossible choice just to keep their job. A court, thankfully, said the policy was not job-related, and it constituted illegal disparate impact against women.
That is just, it's genuinely shocking. So to sum up the strategic difference here, EPA is for that clear-cut case, unequal pay for equal work based on sex. But Title VII is much broader. It covers all protected classes, and you use it to challenge the practices, the tests, the policies that act as an unfair gatekeeper to compensation in the first place. Okay, let's shift gears completely now and look at compensation from the bottom up, the minimum wage. This is where we find not just, widespread violations of the law, but also some really complex, counterintuitive economic arguments against the whole idea of a wage floor.
Right. This is a thorny academic debate, but it's one you really need to understand to see the whole picture of labor economics. The core economic critique is that wage floors can, ironically, make it easier for employers to discriminate.
How does that even work? I mean, it feels like setting a minimum standard would have to promote fairness.
It does seem that way. But think about it like this. In a totally free, unregulated market, discrimination actually costs the employer money. So if an employer is prejudiced against, say, Group A, they might prefer to hire a less productive worker from Group B at a higher rate rather than an equally productive worker from Group A at a lower rate. That cost difference is the financial penalty they pay for their prejudice. But when a minimum wage is set, the cost of labor for both groups gets equalized.
I see. So if the price is the same for every worker, the employer's financial reason to overcome their prejudice just vanishes.
It vanishes, exactly. They're now free to hire based on characteristics other than productivity or price. Their personal biases can dictate hiring, and there's no financial penalty for it. They're no longer punished for excluding the equally qualified, cheaper worker.
And this isn't just a theory. Our sources point out this mechanism has actually been used in history
Yeah.
with malicious intent.
That's the chilling part of it. For example, in the early 20th century in the South, the white-only Brotherhood of Locomotive Firemen, they agitated for equal wages for black and white firemen. They knew that if railways were forced to pay the same rate, the discriminatory employers would always choose the white workers, and it would push black workers out of the industry. And we saw very similar tactics used by the white regime under apartheid in South Africa to hamstring black labor participation.
It's a powerful reminder of how a policy that's meant to protect can actually be twisted by existing prejudice. But okay, regardless of that whole debate, the reality on the ground is that the laws that do exist are being ignored on a massive scale. Let's talk about wage theft. The San Diego County survey data from late 2023 is just staggering.
It truly is. It reveals an epidemic that's hiding in plain sight. In San Diego County, 87% of hourly employees surveyed had experienced some form of wage theft in the last year. 49% experienced it regularly.
Almost half.
Almost half. And if you project that nationally, conservative estimates suggest employers are stealing something like $50 billion a year from workers. That number often dwarfs the stats for all property crime combined.
So what does this theft actually look like day to day? Is it just, mistakes on a paycheck?
It's way more insidious than that. The most common types were unpaid off-the-clock work. 58% of employees reported that. That means having to set up before you clock in or clean up after you've already clocked out. We also see employer-created conditions that prevent legally required rest breaks. That was 55%. Missed meal breaks, 47%. Even simple minimum wage violations were found in a quarter of the entire workforce they surveyed.
But the most crucial finding, the thing you really need to take away from this, is the knowledge gap.
This is the most alarming detail in our entire deep dive, I think. Despite 87% of workers experiencing these illegal practices, 87% of those victims did not know they had experienced wage theft. They just accepted it. Working off the clock, missed breaks. They thought it was just part of the job.
Wait, hold on. 87% of the victims didn't even realize a crime had been committed against them.
Precisely. They are totally unaware of their basic rights. And to make it worse, almost 90% didn't know where to even file a complaint. So it's no surprise that only 2% actually filed a formal complaint, and that's largely because of a very real fear of retaliation. Getting your hours cut, being demoted, or just getting fired. The whole system relies on a worker knowing their rights and being willing to risk their job, and both of those things are almost completely absent.
Before we close out, let's look internationally for one more form of institutionalized pay disparity: age discrimination, which in some places is perfectly legal.
Right. We turn to the UK here, where age banding legally allows younger workers to be paid substantially less for doing the exact same job as an older worker. For instance, workers aged 18 to 20 currently earn less than 82% of the adult rate. And for 16 and 17-year-olds, it's less than 62%. It is a formal legal system of lower pay for young adults.
And what are the consequences of a system like that?
They're measurable, and they're significant. We see data from Scotland showing that over 36% of 18 to 24-year-olds are paid below the real living wage there. Survey results show 84% of young workers have to limit their social life because of it, and 66% report being in debt as a direct result of this lower legal pay floor. And this is not the global standard. Countries like Germany, Spain, France, New Zealand, they all pay their 18 to 20-year-olds 100% of the adult rate.
So this whole deep dive has really spanned the entire landscape of compensation. From the personal steps you can take to successfully negotiate a raise, to the powerful protections of the Equal Pay Act and the disparate impact doctrine that fight structural bias, and then finally to the grim reality of wage theft and legally sanctioned age discrimination at the very bottom.
And the central theme, the thread connecting all of these pieces, is that the effectiveness of any labor law, it doesn't matter how strong it is on paper, it relies entirely on the worker's knowledge. Whether you're using Title VII to argue that a neutral policy is hurting your career, or you're simply recognizing that being forced to work off the clock is illegal. A fact that 87% of victims in San Diego miss knowledge is your primary defense against being exploited.
We're left with a staggering reality. We have the laws, but these massive knowledge gaps and the very real fear of retaliation just prevent any kind of enforcement. So we'll leave you with this question to think about. If proactive enforcement and massive public education are required to fight a system where employers can steal billions simply because their workers don't know they're being robbed, what structural changes, beyond just passing another law or setting a higher minimum wage, are necessary to truly guarantee that every single worker can claim the pay they are legally and morally entitled to?